Good morning, everyone. Welcome to the COVID-19 Access to Justice Task Force. I wanted to thank the task force and the committee members for your continued commitment and engagement over the past few months. The committees have been hard at work developing short and long-term strategies for our task force. And since our last meeting, excuse me, we've advanced several short-term action items. I think you know we petitioned the governor, we petitioned the chief judge to extend the moratoria on evictions and debt collection cases. We also separately urged the governor to allocate $145 million of the state's $2.4 billion in CARES Act funding, for rental assistance, civil legal aid, counseling services, and other urgent civil legal needs. We deeply appreciate your prompt review and approval of those actions. I want to say special thanks to our friends in the General Assembly in the House and the Senate, and to our local and federal elected officials who've been supporting this work by holding hearings, sending letters, requests, and so forth. Additional short-term proposals continue to be vetted within the committees, and we'll continue to elevate those proposals for your consideration as they become available. Of course, sending these letters is simply the first step. We really have to continue to amplify Marylanders' civil legal needs, the impact of the pandemic, particularly on Black and Latinx communities, and the importance of funding civil legal aid. Today, we hope to hear your thoughts on how we can use this task force to accomplish these goals. One way we can amplify these issues is by tracking and publicizing data illustrating Marylanders' experiences in the civil legal system. I'm excited to see that our data and legal technology group has developed. I'm looking forward to seeing what they have developed in support of that effort. And as we reach the midpoint of our work, task force members have also begun to engage the public directly. 2 weeks ago, we held the first in a series of community outreach events to educate residents in Maryland on the critical civil legal justice issues. The August 31st event, which covered evictions, featured representatives from Maryland Legal Aid and the Public Justice Center. Thanks to our speakers, to the Public Awareness Community Engagement Committee, and to each of you for helping to promote that discussion. It's now received more than 2,200 views on YouTube. We believe will continue to be useful to folks facing housing issues for some time to come. We'll hear more today on the other forums that are being developed for the coming weeks. And looking beyond the short-term action items, committees have also made significant progress in developing long-term proposals for reform. Earlier this week, we circulated 45 draft recommendations that the committees have developed for your review and your input. And I want to thank the committees for that extraordinary productivity. We're eager to hear your initial thoughts and have set aside a significant portion of today's meeting for the purpose of discussing those 45 recommendations. We're looking forward to a very robust discussion. That will follow, I think, a short conversation that Rena Shaw will lead, and Rena is one of the vice chairs, and Judge Andre Davis is the other. So Rena will talk about one particular short-term action that we would like to address. and then Judge Davis will talk about the committee's work, and we'll spend some significant time on that portion. So with that, Rena, why don't you take it away?
Thank you so much, Attorney General Frosch. I really appreciate the opportunity. So welcome, everybody. As Attorney General Frosch mentioned, there's been a lot of work happening within the 10 committees of the task force. One of our committees is the Civil Legal Aid Funding Committee, and they have written a letter, drafted a letter that would go to foundations in Maryland. So it would be private, family, corporate, or community foundations that are primarily based in Maryland. And the thought of that committee, because the Maryland Legal Services Corporation, who's the primary funder of civil legal aid in Maryland, their shortfall, even through the process while we've been in this task force, initially they had projected a shortfall, starting at 5 million, and now it's all the way up to 10 million because of different things that have happened, including falling interest rates on IOLTA accounts, banks not paying certain types of interest rates, filing fee surcharges being down. So they also know, besides the funding that civil legal aid organizations that receive through MLSC, funding through philanthropy is another big source. And so they thought it was important for the task force to address the philanthropic community, to let them know of the shortfall and really let them know of the connection between many of the things that, you care about. Food, well, there is a legal services component to that. You care about housing, there's a legal services component to that. So really clarify those and encourage philanthropy to also consider, either giving at the rate or just increasing the giving to civil legal aid communities. So that letter has been drafted by the committee, has been was included in the packet of information that was sent to you all. And we would like to see if we could get approval to send that letter on behalf of the task force. The letter would be due to some of the ethical concerns that Attorney General Frosch raised, would be sent, signed by the vice chairs of the task force under the cover of the task force. So that is what we are asking for the task force to consider now, and see if we can get approval to send that letter.
Rena, this is Franklin Baker, the co-chair of the Public Awareness and Community Outreach Committee. From our perspective, we're 100% supportive of the letter going out, meets the expectations of our group, and excited about it going out.
Let me ask this. Does anybody have any reservations, or does anybody object to sending the letter?
I do not. Robert Bell
Thank you,
here.
Chief.
Mm-hmm.
Thank you, Chief.
Attorney General Frosch.
Yes.
Robin Murphy from Disability Rights Maryland. Totally support the letter, but I do would ask that the committee consider an addition. I did not see an emphasis or a listing of ensuring the availability of affordable and accessible housing. I see ensuring stability, but we can't lose sight of the fact that it's not just evictions, that it's efforts to maintain what's there and also to expand what's there for people so they have a place to live. And I didn't see anything about healthcare, which I think is really important. When philanthropists are looking at this, they will be really focusing on what's listed here. And so I think that's an important part of the work of the task force. And just ask the committee consider adding those two things. And then there is an issue with education not being in here. I don't think today is the day to address that. I know that hasn't been addressed by the task force, but at some point we need to be looking at the digital divide and the tremendous impact COVID-19 is having for all students, but particularly students who are living at or near the poverty level with disabilities, and students of color. But totally support the letter.
So we have two ways to go here. Ron, I think if we're going to amend the letter, people ought to have an opportunity to see it. And so we could delay for a couple of days if you wanted to send in specific changes. We could shoot it out to the committee and ask if anyone has any objections. I think unless someone has objections in general, I think I'm hearing a consensus that it's a good idea. And if you want to make specific changes to the text, why don't you send that to Rena? We'll send out a revised version, give people an opportunity to object. And if no one does within, say, 2 days, we'll send the letter. Does that sound reasonable to folks?
Attorney General Frosch, I'm on that committee, and the focus of our attention is the legal service providers and the deficiency in the funding for the legal service providers. So it wasn't intended to be a comprehensive letter for every need in the state of Maryland. It was a focused attention on a particular need, and that's why it's drafted with that as the focus. So, I mean, we could amend it for every need that exists, but this is really a targeted letter for a specific purpose from that committee.
Mr. Attorney General, good morning.
Yes, Wilhelm, how are you?
How are you doing today?
Good. You?
Yeah, I'm hanging in there. Lots of challenges. That is definitely a good thing to do. My only question is, in this political environment and a political process, what else, or how do we increase the probability of a positive response? What are we doing in addition to this letter?
Well, we're planning to ask the General Assembly to take action on many of the things that we're going to recommend. Some of them will fall in the administration's lap, the governor's lap. Some will fall in the judiciary's lap. And so the answer, I guess, is it depends. We don't want to just be shooting recommendations out and having them fall into a void. But I think, and I saw Delegate Bartlett on here, I'm not sure who else among our legislative representatives has joined us, but I know the main focus of our recommendations is going to be for legislative action. There'll be other things that we're asking for. An increase in funding for legal services, of course, is beyond the power of the General Assembly. The governor's got to put it in the budget, or the General Assembly has to find a funding source and pass a law to create the additional money. But the point is, there are going to be different paths for the different proposals. And I think it serves a useful purpose. I mean, we wrote and said, take $145 million from the CARES Act funding that our state has received and devote it to housing security and legal services. And we've not gotten a response from the governor. We hope to be able to build some public pressure to bring force to our ideas. And we do have a communications strategy or committee that is looking at steps we can take to amplify our messages. But a lot of the work that we do is going to be advisory, and then it's going to be up to us to twist the arms of the folks who have the ability to make these things come to life.
Attorney General, if I may?
Yes. Who's
Excuse
that?
me. This is Susan Ehrlichman. I'm co-chair of
Hi,
the Civil
Susan.
Legal Aid Funding Committee. Hi, good to see all of you today. I just wanted to address specifically the foundation letter. As it was already stated, the list was really supposed to be illustrative and not comprehensive of every issue that we felt was important. And the Maryland Legal Services Corporation has an opportunity to present to the Maryland Philanthropy Network this next Friday, September 25th. So we were hoping to get this letter out prior to that, hopefully no later than next Wednesday or Thursday, the very latest. So if there is going to be some wordsmithing, I would just ask that, there be a very quick turnaround so we could accomplish issuing the letter.
And General
Let me
Frost,
ask
can I
this.
just, I'm sorry, can I just add one thing? In terms, we sent an email, the judiciary members, we sent an email to RENA, but because of the conflict potentially with legislation that could come before us at some later time, we have to abstain from any votes on these if we do take a vote. And we would ask if we could just be noted as a judiciary member as having abstained, just so that there's nothing either unethical or conflict for us. Thank you.
Thank you, Judge Mayer. Yeah, absolutely. I mean, I don't think we could do a roll call, but it would take a long time.
Exactly.
And we're not going to have a recorded vote is the short answer. So, but we will take care to make sure that whenever there is a vote that impacts the work of the judiciary, all the members of the judiciary who are on the task force are recorded as abstaining.
Thank you very much, General Frost. We appreciate it.
Yeah. Let me ask this, Robin. If we certainly intend to address all of the areas that you suggested be mentioned in the letter, since it does address funding for legal services, and because of the timeline of trying to catch the meeting of the philanthropists next week, would you feel comfortable if we said, look, we'll make sure we touch all those bases in future communications, but right now we're just asking for money for legal services?
Yes, I'd feel very comfortable. I really appreciate the work that the committee has done. I just want people to be mindful. I mean, Disability Rights Maryland considers itself a legal services provider, and some of the important work we do for people with disabilities is making sure there's affordable, accessible housing, and also healthcare can be key to whether a person lives in an institution or can live in the community. So I want I want the needs of the people with disabilities that we meet on a daily basis as legal services providers just acknowledge. That's all.
Yeah.
And I have full confidence in Maryland Legal Services Corporation to convey that message to the foundations.
Okay.
So I will withdraw my request with the caveat that you've put in. Thank you very much.
Well, absolutely. Thank you. All right. Does anybody object to sending this letter? Okay. We'll send the letter. We'll note that the members of the judiciary did not participate in the decision to send it. Okay, I think we're ready for Judge Davis to talk about the work of the different committees. Well, the committee chairs and members will be discussing the recommendations, but Judge Davis, I think, is going to lead the discussion.
Thank you, Mr. Attorney General, and good morning, one and all. Thank you so much for joining us. As you can see very readily from the significant recommendations that have been put forward by our hardworking committees, there is a lot for your consideration. So I want to start by simply inviting you after today's meeting on further reflection about the recommendations to commit to writing an email or by snail mail, if that's better for you, any additional thoughts beyond what you hear and what you expressed today to further the work of the task force. It really was a remarkable process. And again, I want to take my hat off, and I know the Attorney General and Rena and Zanita join me in thanking our committee co-chairs and the members and the hard work that they put into developing and tweaking and evaluating and tweaking again these remarkable recommendations. So this is an opportunity for you to weigh in informally with whatever thoughts you wish to express to the committee chairs and to us in the leadership of the task force. The overarching questions that we're looking to hear from you about as a general matter have to do with basically 4 areas as you look through the recommendations. Number one, with regard to timing, are there any recommendations that we should act with greater urgency than others? What we're looking forward to, of course, is our final report and recommendations in December. But there may be some areas here in the middle of September or early October that really scream at you as needing immediate attention, and perhaps we should take steps now to get those into the public sphere. And if you feel that way, please let us know. Number 2, as you review the recommendations, is the scope and breadth of the concerns that have been addressed appropriate? That is to say, do any recommendations go too far, given the arguably limited nature of the task force, focused as it is on COVID-related access to justice issues, or do any of the recommendations not go far enough? Are there opportunities that may be unaddressed by even these robust recommendations, as you can see? And related to that, are there any recommendations that just aren't there, that ought to be there in any discrete way? And then finally, have all appropriate perspectives. And Robin's point in a few minutes ago about disability concerns, which we have been mindful of as we've done the work in the committees. But are there any additional perspectives that have not been appropriately addressed in any of these recommendations? So that's a lot, I know. And again, I want to emphasize that there will be further opportunities for you to weigh in. But I think what we want to do is walk through these and invite your comments as you deem appropriate, starting with the race and equity, the Policy and Race Equity Committee's recommendations with regard to recommendations number 1, 2, 3, 4, 1, 2, and 3. So Rena, do you want to take the lead on those particular recommendations?
I mean, I think today we were really just hoping to see if there were thoughts from the task force members, on those particular recommendations. We did, there are some questions from the committee itself. If there aren't questions from the task force members, but really we want to give the first opportunity for the task force members to raise any questions, concerns, or thoughts they may have on those recommendations.
So the floor is open. We have the recommendation that Maryland Emergency Management Planning Agency tweak its notification and disaster response plans notices. We're calling for an increase in transparency. When the state and local governments get money, it seems to be a good idea that people ought to know that that money's been received and how the decision makers propose to use that money. Transparency is a pathway to good government and accountability. We think that's important. Okay, I think those are pretty sensible, common sense recommendations. And again, I want to emphasize, if additional thoughts occur to anyone after today's meeting, please, we want to hear from you. Let's move on to the housing recommendations. That has been a real concern, of course, not just in our task force and in the Housing Security Committee, but really it's difficult to pick up a newspaper these days or turn on the radio and not hear concerns being expressed about the housing situation that's facing the people in our communities. As most of you are aware, I'm sure there is a moratorium in place. I have said in our committee meetings that I think it's a good idea that the moratorium has been extended through January. And the reason I say that is because I can't imagine that we're going to permit evictions to take place in January. So I think extending moratoria through January likely means that there will be a further extension in some form or fashion. But the bottom line here, of course, on housing as well as on consumer protection and debt collection is that the piper's going to have to be paid at some point. And so I'm going to invite the committee chairs of the Housing Security Committee to take the lead on addressing some of these recommendations from the Housing Committee.
Well, thank you, Judge Davis. I'm Zafar Shah. I'm one of the co-chairs with Zach Shirley of the Housing Security Committee. We produced 3 sort of long form proposals that have been broken down in the draft summary into 8 different points of proposal. And so these sort of break into addressing the renter and eviction crisis, addressing also preservation of home ownership, and then also addressing homeless persons issues. And just going through this in broad strokes so we can get your feedback, really on the renter and eviction issue area, we've proposed really to address a pre-trial mechanisms at trial, and then reducing harm after trial in the type of eviction case that's most predominant, which is failure to pay rent cases. And so the pretrial recommendation is really to use a sort of first step requirement to even filing an eviction, which would bring early engagement between landlord and tenant to try to mediate, negotiate payment plans, and treat litigation as a later resort rather than the first resort. We've proposed a sort of bifurcating of the traditional rapid non-payment of rent ejectment process, so that there's more of a attention put on diverting renters from eviction, avoiding judgment, and providing assistance, whether it's legal assistance, financial or social services, before there's a crisis level of impending eviction. We're essentially asking for a really inversion of what's the traditional model, which is not to provide those services and help until after judgment. Part of the at trial phase of recommendations is a right to counsel, and providing not only counsel for trial, but also for mediation or settlement conference. Mediation is something where we've recommended happen not only in that early engagement, but also as a second opportunity when a tenant engages with the court system at their first proceeding. Overall, we've recommended that there be this kind of triage for defendants at the court, and the court is facilitating that basically a wraparound approach to eviction diversion, and then holding a second proceeding within 14 days to address concerns that have to be litigated if resolutions can't be worked out otherwise. In the harm reduction part of our proposal on evictions, we're looking to address the total lack of regulation on tenant screening in Maryland. As many of you know, the screening of tenants when they're applying for leases, especially after they've lost housing, can impede their rehousing effort and perpetuate the harms, both economic and health harms that come with not being able to rehouse. We've also asked for basically an expansion of discretion for judges. Right now, judges have their hands tied behind their back when defendants are articulating different grounds for a stay of eviction that the current real property code does not allow for. So whether it's just economic hardship, health hardship, those are the types of grounds that courts cannot address right now. Even more importantly, we think, are grounds based on the circumstances of rehousing. So if rehousing will take a very long time, then we ask for discretion. The judges have discretion to account for that rehousing effort and make that part of the factor in how long a stay of eviction may be. Finally, we're looking at the benefit of eviction data as well as the harm of eviction data. So on the helpful side, we've proposed that there be open access to information.
That's outside already.
I don't know what happened just now.
Accidentally muted you. If you could just go, thank you.
Okay, go ahead, Zafar.
Yeah, hey, can you hear me now? All right. Yeah. So what I was saying was basically if we can provide open access to data that is geocoded by zip code, it's going to allow public policy analysis, by multiple different settings, whether it's academic, professional, different advocacy efforts can be helped through geospatial analysis of eviction throughout the state. Currently, you only see that in sort of one-shot efforts in Baltimore City or Montgomery County.
Okay, Zafar, thank you so much for that really comprehensive summary of some of the recommendations. You will not disagree with me when I say that your committee's work was intense and broad-based and comprehensive, and that your aspirations are just that, significant aspirations that will require consideration if they come out in our report, will require consideration by the judiciary as well as by the legislative branch. I want to open it up and see if any of the task force members, with the benefit of your summary and having reviewed to a greater or lesser extent any of the recommendations, whether any members of the task force wish to weigh in at this point.
Judge Davis, can you hear me?
I can, yes.
It's Congressman Sarbanes. I've been listening on while I've been driving in from Baltimore to Washington, and I just wanted to thank everybody for their work. Thank the Attorney General for having convened this, and privileged to listen in and participate where I can. I just wanted to say on the housing, as you know, one of the key elements of the HEROES Act that we're pushing as hard as we can for right now is to actually put dollars behind this rental crisis and mortgage crisis that's looming, because the moratorium without support coming in behind it at the point the moratorium expires is really just putting people close to the precipice. So we're pushing for, I think, $100 billion in rental assistance, $75 billion in mortgage assistance. But I think it's going to be really important, and I thank the task force and this particular committee for our federal delegation to understand exactly what it's going to look like on the ground when it comes to crunch time at the end of this moratorium, and to understand how we can design whatever the particulars are of the support and relief we want to offer, so that it's the most effective thing that we can do. I have one real quick question because it came up in our caucus the other day. We have been hearing that while there may be a moratorium on evictions based on failure to pay, that some landlords were finding other pretexts for evictions that somehow short circuit the moratorium. I didn't know if that was true, but it was a topic that came up on one of our caucus calls. So just if you'd indulge just a couple of seconds to have someone respond to that. Otherwise, I'll yield back my time, as we say, and again, appreciate the work of the task force.
Thank you very much, Congressman. I think the Attorney General wants to address that briefly.
Yeah, I would. First of all, Congressman, thank you very much for joining us, spending your commute with us, and thanks for everything you're doing on Capitol Hill. You've been absolutely terrific. The short answer to your question is yes, the moratorium is not effective on a blanket basis. And landlords started, because of the nature of the moratorium that Governor Hogan had imposed, started filing tenant holding over cases even before the federal moratorium expired on, the first moratorium expired on, I think it was July 31st. And with that, the difference between a tenant failure to pay rent case and a tenant holding over case is this. A failure to pay rent case is exactly what it sounds like. Didn't pay the rent for June. A tenant holding over case is a case in which the tenant's lease has expired and the tenant is month to month. And the landlord doesn't have to renew that case. If they don't like the tenant, they fear the tenant's not going to pay the rent, or just, feel like it, they can file an eviction action based on the fact that the tenant no longer has a right under the lease to remain there, and the landlord prefers to get a new tenant. Well, we've been in this crisis for 6 months. The moratorium lasted until, the full moratorium lasted until July 31st. So since, during that period, probably half of the tenants' leases have expired, because it's unusual for a tenant, especially in housing that is less expensive, to have a lease that's more than 1 year. So there are lots of eviction cases that, and someone else can correct me if I'm wrong on this, but there are lots of eviction cases that are going to move forward in Maryland, regardless of the fact that we have a federal moratorium or, Governor Hogan's partial moratorium still in effect.
General Frost, I just want to mention one other type of case for which a warrant of restitution or eviction proceeding is instituted. And those are non-tenant cases, people without any lawful right to be in the property, the wrongful detainer action. And, you do see those actions both for, people that are, what some people refer to as quote unquote squatters, but also you see people who have no tenancy, no right to be there, and there are acts of violence between the owner of the property and the individual who has been there. And those are cases where, those victims of the acts of violence do want that individual out, who does not have any lawful right to be there any longer. And those wrongful detainer cases do come before the court. And they are cases for which there are requests for warrants of restitution should a judgment for repossession be entered. And that's sort of an entirely different category of cases probably than what this task force may be talking about for these, but those do exist and occur.
Thank you. And Congressman, just so you know, that was Judge Stacey Mayer. So pretty sure she knows what she's talking about.
Thanks very much. I appreciate it.
Judge Davis, you're on mute.
Any other questions or comments on the housing recommendations from members of the task force?
I'm sorry, this is Judge Mayer again. I'm sorry to say one more thing.
Yes,
In terms
Judge.
of the available eviction data, we have started voluntarily reporting certain eviction data with our conversion to an electronic filing system. Most of the rent actions have not yet been converted to an electronic system. So, we're hoping and trying to be as helpful with that data as possible. We do have some data limitations, unfortunately, these are all paper filings. And so to get that information for these cases requires manual abstraction of that information. I just bring that up because we're hoping eventually to have everything electronic, but the technological limitations are there just for at least at this point.
Thank you, Judge.
If I can, and Judge Davis, if I can interject, it's Mark Skirty.
Yes,
Just
Judge.
to add on to that, there are 3 major jurisdictions that are not on MDEC yet. That's Montgomery County, Prince George's, and Baltimore County. So none of that could be collected.
Baltimore City. Baltimore City.
Baltimore City, I meant, yes. Which is what I said. But information is reported by our sheriff's office, but it's not broken down by zip code or any other collected data. We just need to be mindful of the MDEC, non-MDEC jurisdictions.
Hi, this is Delegate Sandy Bartlett. I just had one quick thing I wanted to add. I was looking at the, and I have talked to Steve about this, the Senate work group on housing and COVID-19 came up with some specific recommendations. And I see that the recommendation that our housing committee has come up with are very much in line with those. There was one question though I had, and I was trying to see if it was in the consumer recommendation and consumer protection. And that is, there was in the Senate report a recommendation with respect to protecting individuals who have been affected by COVID-19, protecting their credit reporting and their credit rating. So I wanted to see, and if it's in there, if you could just mention it. If it's not, and if it's coming up under Consumer Protection Committee, then I apologize for not finding it sooner than now.
Thank you, Delegate Bartlett. Steve Sakamoto Wengel, co-chair of the Consumer Protection Committee. That is not an issue that we have addressed in our recommendations. I know that the Housing Committee has some recommendations related to reporting and credit reporting with regard to tenants. But there are limits based on federal preemption as to what we can and cannot, block in credit reports. So we could take a look at that more closely, but I think that is a good recommendation to look at.
Okay, thanks, Steve. And also I see that in the report that the Senate they did lean on the federal delegation a little bit and say that these recommendations also were, intended to be reviewed by them or extended to them as well. So I appreciate you making that point. So to the extent of whatever we can do on the state level with respect to consumer protection of tenants, that would be great. I am hearing that a lot from constituents. Thanks.
Thank you both. Anything further on housing from the task force? Okay, the next 7 or 8 recommendations come from the Economic and Food Security Committee. There are a number of recommendations related to unemployment insurance process and benefit access. Do any members of the task force have any observations or questions, or do any of the members of that committee have any questions Robzovich.
I have a question here, and maybe it's addressed elsewhere. I don't think I've seen it. Whenever we speak about improving access and understanding of information, has the task force already incorporated like second languages in the materials as a recommendation? I haven't seen any specific recommendation regarding languages used other than English, particularly for notices and explanations of processes and other matters.
Wilhelm, I know that's been discussed across a number of the committees as well as in the Equity Committee. That's very much a concern, yes.
I didn't find it as a specific recommendation anywhere.
Okay.
Judge Davis, this is Carno Evans. So I'm one of the chairs of this committee, and I can hopefully address Mr. Joseph's point. I think we do mention providing foreign language access in a couple of different places in the recommendations, and it certainly has been front and center in terms of the things we've been thinking about and talking about in terms of providing expanded access to information regarding benefits. So I think it's covered here in a couple of different ways. It may need to be made a little more explicit, but certainly that is something that as a committee we have been very mindful of in terms of disseminating information as widely as possible, but also in as many ways as possible to reach as broad an audience as possible.
Well, thank you. It is not too difficult. If you could make it rise to the level of its own recommendation, a general across the board might be.
Okay. Yep. I think we could do that. Thank you for the suggestion.
Thank you, Wilhelm. Anyone else? Yes, Marceline.
Hi, thank you so much for these recommendations. Just a couple of questions and comments. I really appreciate the work that's gone into this. We do some work in my organization helping people mainly with financial assistance, financial security and counseling, but have been really engaged in the UI system recently. So a couple questions for the committee to consider. On 13, you're talking about a community outreach program, which I think is a great idea. I'm wondering if there's been consideration of having the department partner with nonprofit organizations and community-based organizations on that kind of community outreach, because oftentimes organizations that are closer to the ground may be better validators or more able to get the information out and disseminate it in an effective way to community-based leaders. So that's one question. And then on 14, I think this is a great idea. In addition to the hotline, and this may be what you mean by the hotline, but one of the things we've been asking for from the Department of Labor and have not received was something like a single point of contact so that our social workers could call someone to help people once they've put their UI application in and get assistance. And we'd not received that. So is that sort of what you mean by a hotline where advocates and nonprofits can really help assist more than just completing the application? And if so, we'd support that or some kind of single point of contact that we had in the foreclosure context.
So I'll take your second question first. So I think, yes, that is what we're thinking about, is some way that if not the applicant, but certainly the advocate for the applicant can reach out to somebody directly and get information, as opposed to just going into this endless loop of not being able to sort of get current and accurate information. I think we're all for sort of being able to be as transparent and as up to date in the process as is possible. So I think it probably can take a number of forms, but yes, I think is the short answer to your question. That's what we're thinking about. To get to your first question about number 13, we absolutely have been talking about partnering with community-based organizations which may have sort of more feet on the ground in places where there are people who would be trying to access these kind of benefits. And so we've even sort of begun some discussions about what those organizations might be and existing sort of events and ways that these organizations are already out in the community providing information, and whether we could leverage some of those kind of existing events to disseminate information as well. So absolutely, we think that's going to be critical, and that's probably going to be the most effective way to get this to happen.
Thank you. Anyone else? Do members of the task force have a view about the recommendation regarding increased eligibility for Medicaid? Is that an issue that's appropriately included in this context, or is that a bridge too far? I'm being devil's advocate here, perhaps to generate some thoughts on the part of the task force. Committee's done great work on this. I'm not being critical, just raising the question of whether it's an appropriate time and place for that, if anyone has any views. Carnot, did you want to address that briefly?
Sure. So, I mean, I think, our thinking was, to think probably a little more broadly than a little more narrowly. And so, this was certainly sort of one of the charges of our committee, was to think about, Medicaid and how it might function sort of better for Marylanders. And so, I think, I guess, you might say, well, that's sort of outside the charge of this committee. But I think, given lack of access to insurance, particularly as people lose employment, I think that it's an issue that a lot of Marylanders are confronting these days. And so, our thought was, if there's a way when they apply for one benefit to apply for another benefit, maybe we're just sort of making the process easier and getting people access to healthcare who wouldn't have it otherwise. So that was the thinking of the committee, is to probably be a little more over-inclusive than under-inclusive.
Great. Thank you so much.
Sure.
Judge, could I make a comment?
Yes, of course.
The partly because of what our office does, we set up the task force to deal with justice issues. And I think in the traditional sense, that means how people relate to the courts, how I'm not sure how to expand it beyond that, but I mean, we have a recommendation in there to increase SNAP benefits, and these are just basic human rights, it's basic human needs. And while I would say they don't really fit within the access to justice framework that we're thinking about, if we keep them to a minimum, and we're talking about the most important types of human rights, and housing, of course, falls into the access to justice category pretty easily. Food doesn't, maybe unemployment insurance does. But I think as long as we're focusing on the most important and a minimum of the serious funding issues we have that relate to people in poverty, that it's appropriate. I mean, nobody's gonna send us to jail for expanding our reach a little bit, and I think it's appropriate in limited circumstances.
Well said. Thank you, Mr. Attorney General. Anyone else?
Judge Davis?
Yes.
This is Robin Murphy from Disability Rights Maryland. I wanted to point out the SNAP benefits and TANF and also Medicaid all are subject to denial and administrative hearing process. So while it's not just not limited, access to justice isn't just limited to the court system, it's the administrative hearing process. And we do many cases where people really, really need the support through that process and need it made user-friendly. So I would advocate to keep that in. And also medical care can be the difference between people being able to work, being able to pay their rent, being able to live outside of a nursing home. So from our perspective, it's very important to keep those portions in there.
Great point, Robin. Thank you. Anyone else? Okay, as you can see, the Consumer Protection Committee was very, very busy with lots and lots of issues on its plate. So I invite any feedback or questions or observations about that batch of recommendations.
Judge Davis, the judiciary had comments on several of them, just for purposes of discussion or consideration. I can do them one at a time or just sort of run through briefly.
That's great, Judge.
On number 22, which talks about court forms, which I think is a great topic. I think it's important to note that there is a forms subcommittee that exists within the judiciary that entertains outside requests on a regular basis to review or to create new forms. And we literally have thousands of forms at this point that are posted to allow access. And I mean, this started with Chief Judge Bell. And a lot of the forms go back a ways. For the last many years, there has been a language subcommittee that looks at those to review them to make sure that they are at an appropriate reading level and they are accessible. So to the extent that this recommendation mentions two specific forms, I think for it to be actionable by us, it would be helpful if people can make specific recommendations as opposed to review all forms. I would imagine there are some that are older that didn't go through the language subcommittee that we could retool, but if it was focused better, I think we would be able to look at it more clearly. The second point I wanted to make is on number 25, which is talking about electronic signatures. As we mentioned earlier, the three largest counties are still converting to MDEC, and the whole electronic signature and what to accept or not accept is being addressed by the Rules Committee as we get to a point where all courts will be on that. So I think that that's a review that is in progress, but appreciate sort of the note on that, that it's something that we should continue to look at. I do think during court closure, there was some experiment with email filings in several of the non-MDEC courts. And it was extremely problematic for the court clerks to manage email filings of papers. I mean, essentially, they then have to print paper file. So I think to some extent, this is a time-limited recommendation because the other courts will be converting to an electronic filing system. The 26th, the one after that, which talks about the Rules Committee, the governance of that is set by rule and is governed by the Court of Appeals. I would note, though, that all of the Rules Committee meetings, they're an open forum. It's under the Open Meetings Act. They are open to all and can be attended by all. So it's a matter of sort of integrating within that process as opposed to getting somebody appointed to the committee itself. And then again, just to the extent that there's some legislative recommendations in here, we certainly are interested in the suggestions that are being made, but those were things that we'd have to abstain on and just deal with in the legislative process in our normal course.
Of course. Thank you so much, Judge. Anyone else? Yeah, yes.
Yeah, Glenn, thank you, Judge Cox, for those comments and questions. And just as to the first one with regard to the forms, we are aware of the Forms Committee. And I guess we were instructed at this point to just be able to come up with the higher level recommendation and not necessarily get into the details if we haven't worked those out yet. And we are still working on the on those forms. The two forms that were mentioned were the ones that are prominent in debt collection actions and small claims court. The complaint form, as well as the writ of summons and notice of intention to defend form. And our committee is continuing to work to look at those forms. And in addition to just the language and how understandable the language on the forms is, some of the concern is involves the layout of the forms as well, and how cluttered they may or may not be. So we are looking at those. I understand that in failure to pay rent cases, the courts are temporarily affixing a sticker to the papers being served on tenants, advising them to contact the self-help center for assistance. And we've raised the issue, which I understand is under consideration, as to whether something similar should be done in the meantime with small claims, collection actions, in addition to the failure to pay rent actions. So, but thank you for your comments on those.
Thank you, Steve. Anyone else?
I'm looking at my notes. I forgot to comment on one other thing. On 28, where it talks about the body attachment process, I do think there's a comment in there that may be construed. There's a comment that says the sheriff can arrest a debtor and force them to pay the debt in order to be released, which I don't think is consistent with Maryland law or practice. I do think that there's some proposals for some review of the rules or perhaps legislation in that area, but the existing process would require a next, a day of pickup or next open court date review. And there isn't a process where we can mandate payment of the debt. So I just think we should be clear on that.
So noted, Judge.
And we appreciate that. I think what advocates who work on the ground have seen is just that the statute has been applied differently in different jurisdictions. So there's been a lot of confusion about actual implementation of the current rules. But I think we will be looking at legislation in terms of body attachments.
Yeah, and absolutely agree that there may be some legislative or rule changes that would make a more consistent practice statewide.
Great.
I have a question about 23. Could the exemption from freezing of these funds actually be achieved by an executive order? I put that to the committee. Yes.
The idea was looking at it as a shorter term action. If it could, that other states have issued similar kinds of executive orders. So, I think there's a little bit of a question, but looking at what other states have done, they've done that in terms of creating sort of a safe harbor for those kinds of protections to exempt. But if not, it's the type of thing that we would just want to clarify, I think possibly in legislation, if not.
I think your point.
Just to jump in real quick, the governor's current executive order does exempt CARES Act funding from writs of garnishment. So I guess that leaves open the question whether or not it's lawful, but it is certainly included within his current executive order, an exemption of the writ of garnishment for CARES Act funding.
That's right. But this is talking about the retirement plans and veterans.
I understand. I'm just saying there's precedent for it in an executive order.
Yep, agreed, 100%.
Okay. But my understanding, this recommendation would continue long after COVID is a bad memory for us, correct?
Yes, I think
seeking to achieve a permanent change in the practices, which would be a regulatory thing, I suspect that bank regulators could achieve.
Well, and as you can see, it's already automatically exempt under the Maryland Code. But there's an issue with the banks.
The freezing of it for a few days.
Exactly.
Yeah. Okay. Anything further on those recommendations?
If I could, I just wanted to note that, a lot of the focus of the Consumer Protection Committee has been on debt collection, and note that it's been issues that predated the COVID-19 pandemic, and that communities of color have been particularly hard hit by debt collection actions, and there's been at least a perception that the courts are just being used as a judgment factory for getting judgments against debtors having trouble paying their bills, and one of the concerns is that, there's historically been a low rate of participation in the process by people who are sued in debt collection actions. And I think that the number we were given was about 10% of people might actually, show up in court. And so one of our concerns is, how do we get people more involved, when they are having debt problems, both to be able to get information before they get sued and try to address their debt situation. Once they do get sued, how to encourage them to participate in the process and get assistance. And so some of the recommendations we do have are, we're, trying to create microsites with information for people who are facing debt problems or who do get sued. Now, a lot of people don't have access to the internet. And if they're also going to go do a Google search for debt issues, how do we get them directed to sites with appropriate information as opposed to, predatory debt relief companies? Another recommendation is, as was previously discussed, establishment of some type of a hotline that can put people in touch with appropriate resources, and whether that should be part of a larger situation, a larger organization like the 211 system or the self-help centers, or whether we need something more specialized, similar to the HOPE hotline that was set up during the foreclosure crisis that connected people to housing counselors. And the third idea on the sticker that I previously discussed is something similar, as something that Judge Skirty brought to our attention during a review of failure to pay rent cases in the district courts. And that was that in Brooklyn, New York, landlords, when they file an eviction action, are required to provide the clerk's office with a simple postcard that identifies, basically, you've been sued, here's the date of your court hearing, it's important you show up, and here's the number to call for more information, and whether and how to go about implementing something like that. So we are looking for ways that we can get people involved, get people in touch with, with available resources, and we really would appreciate any suggestions that members of the task force might have in accomplishing that goal. So
thank you very much. Thank you, Steve.
One thing on Steve's point, I'm sorry to jump in again.
Yes, Judge, no, please.
I'm sorry, the idea of the sticker, great minds thinking alike, is going to be included on the complaint form. So we're targeting for the first of the year because it takes a while for us to do the programming and the new forms, but that will be included.
That's tremendous, Judge. Thank you so much.
How fast we work. All right, thank you.
Yeah.
Thank you, Judge Mayer.
The take-home message here, is please show up. I mean, bottom line, that's what we want people to, if they don't hear anything else, show up, please. Okay, the next group of recommendations come from the Life and Health Planning Committee. Do any task force members have any observations or questions? These call for significant legislative changes. And I think I skipped over the Surviving Abuse, Neglect, and Exploitation Committee. Recommendations 31 through 35.
Can I ask for just clarification on 33, which talks about creating an appeals process? I wasn't clear on the context, because there certainly are some of these, circumstances that would fall under this description that already have court remedies and direct appeal processes. But I wasn't entirely clear of what the scope of that recommendation was trying to address, and a little bit the same thing with 34.
Good
Thanks.
question. Good question,
Judge
Please.
Cox. I am one of the co-chairs of this committee, and so I'll address your question, and maybe our my other co-chair, Shelley Mintz, if she has anything she wants to add. I actually kind of was the one who came up with the this appeals process, because I was concerned about the people who were in, care in a congregate care environment during COVID and could not go to court and could not make a claim through the court process. So if, for instance, there was a, if you're living in an over 65, or if a HUD, I'm sorry, if you're living in a certain environment and if you're being told that you cannot have visitors, but you are healthy and you are able to go outside and you are able to recognize social distancing, perhaps outside at a picnic bench, right outside your facility or something of that sort. It seemed that there was no way to be able to appeal the decision of your, in some cases, your landlord, or at least whoever is providing residential, care for you. And that's what I was thinking of there. Not having personally this is not an area that I work in, but it just seemed to be a problem that a lot of folks were having, that we found in that in the population that we were looking at with respect to elders and some children, juveniles who were not given the physical access. They were given virtual, obviously, but not the physical access to individuals, even though they might have been healthy.
And Delegate Bartlett, this is Shelley, if you can hear me. One of the things too that we were concentrated on in answer to Your Honor's question was in the realm of abuse, neglect, and exploitation. During the pandemic, neither the Ombudsman nor Adult Protective Services were able to physically access many of the people that they serve in congregate care settings, leaving them ripe not simply to exposure to the virus, but also to the whole realm of abuse, neglect, and exploitation, particularly financial exploitation. And many of the individuals in these settings may not have ready access to the internet, to video conferencing, which has been used by many in order to access clients and the like. And Adult Protective Services in particular has under its wing, I think, over 900 persons in state wards who are in guardianship, but could not physically access their clientele. So we wanted to look at at formulating, and it's still in the thought process of how it would look, as expeditious a process as possible to give emergency and rapid access to those who are looking out for this population.
Thanks, Shelley. That's exactly, and that was exactly the problem and the point that we want to make. With respect to 34, with respect to harm reduction, use of substance abuse to prevent overdoses and perhaps to establish clean use. This is a very controversial topic, we know, and it is not necessarily one that has been finalized. It was one that came up in our initial conversation, and the issue was that during COVID, while we were in lockdown mode, there are certain facilities where we already have harm reduction use. However, those facilities were in lockdown, and was that the number of overdoses and the number of non-clean use increased. So that was the thought process around that area as well.
Thank you, Delegate. Any other comments on either life and health planning or the surviving abuse and neglect? Okay, last but certainly not least is civil legal funding. Always a topic of great concern. Susan, you want to offer any thoughts?
Yes, thank you very much, Judge. The committee had done a lot of work initially looking at short-term solutions with regard to trying to obtain some CARES Act money, which, as you know, is part of the large proposal that the task force did submit. We submitted that proposal initially on behalf of Maryland Legal Services Corporation, and legislative members of our committee did submit that on our behalf. Unfortunately, we still have not received a response on that. And given the situation, as Rena described at the top of this meeting very accurately, the situation for the largest funder of legal aid in the state, the Maryland Legal Services Corporation, has changed very significantly since the work of this task force since it began. And now that we are looking at a deficit that's essentially double what we initially thought, the ability to obtain funding in the short term immediately is necessary, or else additional cuts will have to be made this current year. That is something we had not anticipated. We are hoping that the letter to the foundations helps getting some more money directed to our legal aid providers. We are still, we have an upcoming meeting with the governor's office. We've spoken with the judiciary leadership and others to see if there's something we can do with regard to a truly emergency situation we now find ourselves in. With regard to the longer term efforts, essentially not that long term, we're looking at fiscal year 22, the next fiscal year. We are hoping for success in the Maryland General Assembly this coming session. We are working with key legislative leaders in particular committees. At this point, it does seem a bit premature to know exactly what those legislative avenues will be, but we are continuing to explore them. And I invite my co-chair, Kathy Bledsoe, and any other members of the committee to add anything they wish to add to that.
Susan, the urgency of this matter gives me chills.
Mm-hmm.
It affects my daily napping and my nightly sleeping. So you have stated very clearly what the challenge is. If there is no success with the emergency funding, what is your most accurate guesstimate about the impact on funders, particularly your largest recipient? What we're looking at in the current fiscal year, there's already been a 9% cut. What are we looking at in terms of a range, a cut of what?
Mm-hmm. Well, sure. Well, I don't have a precise number for you. I can tell you that unfortunately, if we do not find additional funding, there will likely be significant further reductions, which will lead obviously to less help available, less lawyers being accessible for people who desperately need help as a result of the pandemic.
Let me ask
we
you
are hoping. Mm-hmm.
If you could share with the, because I think sharing the urgency and the particulars would increase the sense of urgency. If you could state, for example, what is the total amount of money you have obligated for the current fiscal year? That would give us a number, and then give us a sense of what the current reductions look like in terms of its impact on that number? In other words, if you give out 16 million, does it mean that you will only have 8 million or something like that? Can you give us at least that kind of estimate? How much do you give out?
Sure. Well, I don't have my spreadsheets with me. I'm actually on vacation, but I'm happy to share with you off the top of my head, because I too certainly find myself pretty consumed with this situation. Last year, the MLSC fund generated approximately $21 million. We were anticipating approximately a 25% loss. Now we are anticipating close to a 50% loss. So that MLSC fund, rather than generate 21 million, will likely generate less than 12. We have already spent significantly from reserves. The board is going to meet again in a few weeks in October. We are looking very carefully, obviously, at all of the data that's coming in with regard to our funding. As many of you know, our major source of funding is from court surcharges on court filing fees. The first 2 months of this fiscal year, that revenue has been half of what it's been in prior years. With regard to IOLTA, we continue to work very, very closely and aggressively to try to get the banks to increase revenue. In this environment of near zero interest rates, it's particularly difficult. So we are continuing to try our best. We are still hoping that perhaps we will be able to have a favorable response on the proposal that was submitted for CARES Act funding, particularly since the situation has become much more dire.
Thank you. Let me again emphasize to everybody, we are the largest recipient, to the tune of almost 12. I have a board meeting coming up. I would like to not to be too dramatic, but lay it on the line as to what this really means. It means, as a possibility, the total grant in 21 being cut in half. Is that a possibility?
I really can't give a number right now. I certainly would hope that that would not be the case. But it will not be, unfortunately, it will be something that is not just tinkering around the edges. This is an unprecedented, truly, I know that word's been very overused since the pandemic began. But Maryland Legal Services Corporation is an institution with a 38-year history. Many on this call have been with us through ups and downs with regard to IOLTA funding and have helped dramatically in those situations. But this is an unprecedented situation for Maryland Legal Services Corporation with regard to not being able to fulfill grant commitments that have been made for a current fiscal year. And the main reason for this is the shortfall in the filing fee surcharge revenue. That is always actually what has saved us when our other major source of funding, went south with regard to not only the vagaries of the economy, but the actions of the Federal Reserve Board. But to have our two major sources of funding take such a significant hit as a result of this pandemic is an unprecedented situation for us.
It's a sobering reality that we've got to address anyway and in every way we can. We have about 1 minute left.
Judge,
yes.
Could I ask a question, Susan? I apologize.
Absolutely, of course.
And this is a long-term issue, I guess. But Susan, I remember that when we were getting court fees for legal services, that there was an issue about whether or not eviction lawsuits were going to be subject to a surcharge. I don't remember the outcome of that. Is it a lower fee than others? And is the moratorium on evictions something that has impacted your revenues?
Attorney General Frosch, the evictions, there is a surcharge, albeit a much lower surcharge on eviction lawsuits. There is a surcharge on all civil legal cases in the circuit and district court. But because of the sheer number of evictions that are typically filed and are not filed, the impact on those cases not being filed certainly plays a very significant role. But other filings are down significantly as well.
Sure. I mean, one of the things that I'm thinking of, is it $5 on an eviction proceeding, or what is it?
$8.
Eight. Well, one potential legislative solution is to raise that a bit. I'm sorry.
Attorney General, I just wanted to add, Baltimore City sees 12 to 15,000 per month, which is 120,000 that is not coming in. And you add that to the other major jurisdictions like Prince George's, Baltimore County, that have similar or higher numbers, and that's substantial revenue that's not being brought in.
Yeah, I mean, this is a very odd situation in which, we want there to be fewer eviction cases filed, but it hurts legal aid in the process.
One other comment
I'm sorry, Judge.
No, please, Susan.
No, I was just going to comment that there's a very cruel irony there. I agree.
And on the raising of fees, I'm always concerned because it's a pass-through to the tenant, and that just increases the housing costs. We just have to be mindful of that as well.
All right. Well, I'm going to turn it back over to the Attorney General and to Rena. I want to reemphasize that we genuinely welcome your thoughts and comments on the recommendations. The committees will go back, consider the thoughts and observations that have been made, and do some additional tweaking and updating. And I believe there will be additional recommendations beyond the 45 that you've reviewed. And we're going to make some decisions and have additional material for you to review at the October meeting. And we very much welcome and value your feedback. I want to again salute the committee chairs and the members of the committee for just remarkable work in putting together these recommendations. Thank you all.
Judge Davis, thank you. That was a great discussion. And let me add my thanks to yours, to the committee chairs and all the committee members. I think we've got a great list of things to address. And as Judge Davis said, there are more yet to come. I think we're going to spend a few minutes now talking about how we might amplify the messages that we're trying to send from this task force. And I think Rena is going to lead us in that discussion.
Thank you, Attorney General Frosch. So as has been mentioned, the task force has been working at breakneck speed because there are so many time-sensitive and urgent issues. So we've been trying, while we're thinking of these long-term changes, also to do short-term recommendations, and that has come in the form of letters to both the governor and the judiciary. We are actually going to likely have midterm recommendations. So between this meeting and the new October meeting, there are some recommendations that came out in the long-term recommendations that may be pushed ahead. And so there will be likely midterm recommendations. And then obviously we've spent a great deal of time in this meeting looking at some of our proposed long-term recommendations. We, at the same time, are also the committees have been busy actually doing, looking at what kind of resources are out there, compiling resource books. Our Public Awareness Committee is going to start a series of community forums. And later we'll also have a review of the beginnings of a civil justice data dashboard. And so these are all things sort of happening together. But one thing that, we notice is that even though we can do the substantive work, which is very important, a big aspect is also how can we use sort of everyone's expertise, weight, gravitas, and influence to do more, because as the Attorney General mentioned at the top, with some of these letters that we have sent, we have not received a response. And so we are thinking through strategies how we can amplify the message. One of the key things that obviously the work of the task force early on in the short-term recommendations has focused on, a large portion of the funding ask was for both rental assistance and civil legal aid funding. And the first letters to the judiciary and the governor, dealt with the moratorium on evictions. We thought the task force, would be interested in perhaps hearing on the ground as to what is happening with some of these issues that you all already have taken some action on. And we wanted to spend a brief amount of time just giving you, an on-the-ground view. And we have some advocates that have come on the call to brief the task force. And hopefully this can also help us think about how our own voices are connected to what people are actually facing on the ground, and how we can then use some of the tactics that I'll go into just in a few minutes and to just amplify this message. So at this point, I'm going to turn it over to Zafar Shah, who is the co-chair of our housing committee and also a member of the Public Justice Center, to do a brief presentation on sort of what is going on with the different moratoriums, with the CDC moratorium, et cetera. We will also hear from Kayla Williams, who is from the Community Legal Services of Prince George's County, about what she's seeing on the ground with the clients that she's representing. Zafar?
Hey, thanks, Rena. So on August 31st, the judiciary began its phase 4 of reopening, beginning dockets for fair to pay rent eviction cases. And we've seen across the state that courts have stringently limited the size of the rent dockets to accommodate safety measures in the district court buildings. At the same time, we've not seen notice to litigants that they may request remote electronic participation in their hearings, and there's uncertainty regarding how courts will proceed when one party requests remote participation based on health risks, but the other party objects. On September 1st, the CDC order to halt evictions through the end of 2020 was announced, and the order set out a public health-based prohibition on landlords taking any action to remove a tenant from their rental property. So the prohibition itself becomes effective whenever a tenant delivers a signed declaration to the landlord, making 7 assertions under penalty of perjury. And these assertions include statements that the tenant has become unable to pay rent because of substantial loss of income, has an income under $99,000 or $198,000 for a couple, or received an electronic stimulus payment, has made best efforts to utilize government assistance, is making partial payments as circumstances permit. So it's a number of assertions, basically promises made in a declaration. And on its face, the CDC order appears to then block not just evictions based, or not just the act of eviction itself, but even the filing of eviction, because it's any action. And it doesn't require proof of all the assertions. It just requires delivery of the signed statement to the landlord. On September 4th, the chief judge of the district court issued a communication to all the local courts recommending that judges interpret the CDC order as an affirmative defense alongside the governor's existing and still effective executive order, which itself explicitly states an affirmative defense against eviction and failure to pay rent cases. And so it appears that what we'll see through the end of the year is that, yes, the courts are still going to accept eviction filings. There will be eviction. The burden is on the tenant to prove up the assertions they've made in the CDC declaration, the CDC order declaration. And judges will enter factual findings for all these cases that are coming up about whether rent is due and owing. So regardless of whether there's a substantial loss of income due to COVID proved up under the executive order of the governor, or the 7 different assertions made by the tenant in the CDC order, if there's rent due and owing, that will be a fact finding. It will be put on the file, so to speak, and then reserved for judgment after December 31st. And Chief Judge Morrissey has explained that reserved judgment means that literally the document will just be held without entry of judgment until after the end of the year. And after that, essentially, those judgments will be entered more or less automatically unless the landlord has come forward in intervening time to explain some change of circumstances for why there shouldn't be judgment entered. So basically, this all sets up a new eviction cliff, a new economic and social disaster for the new year. And so now and through the fall, we expect to see serial filings for eviction, resulting in multiple judgments that will all come due after December 31st. In most of the state, landlords can foreclose the right of redemption, the tenant's right to pay what's due in order to stay in the property before eviction, after just 3 judgments. So that's really the looming disaster. Through all of this, the tenant holding over loophole that the Attorney General mentioned earlier will continue, as the EO, the executive order permits that, and the CDC order doesn't explicitly not permit it. And I can just give you a sense that this is not hypothetical. I just had a client on Monday who was in court we were defending against an eviction based on amounts from December through last March. She has another failure to pay rent case coming up in October based on the summer months of rent. She didn't know she could apply for Baltimore City's housing temporary rental assistance because Department of Social Services had told her earlier in the year that you can only do that once in 12 months, and she'd already done it in 2020. She received a breach of lease notice recently based on non-payment of rent and non-payment of the water bill. She then also received a notice to quit within 60 days. They're basically terminating her month-to-month tenancy. And so there's different ways to get around the protections, and so it's not a hypothetical that tenants are facing a threat from all angles. And overall, as you might guess, legal services attorneys and paralegals are handling a rising caseload, a surge in calls, most of which mean whether evictions are legal if they're happening right now, and whether rent must be paid now or later, and what have you. So from there, I'll let Kayla take it from there.
Hi, good morning, everyone. My name is Kayla Williams. I'm a staff attorney with Community Legal Services, and I provide representation to tenants facing eviction. Prior to the COVID pandemic, we were at the courthouse every day providing same-day representation to low-income individuals. Our services are and have always been free. Of course, however, since the pandemic has taken place, we are back in the courthouse, but unfortunately, a lot of the cases that are being scheduled now, I believe, are still the pre-COVID cases. So a lot of tenants aren't showing up. It seems like a lot of notices are getting lost in the mail. Tenants aren't being notified of their hearings. I've heard instances where tenants were advised that their case was no longer going to be in person, but was going to be heard via Zoom, but they never received the Zoom link. And just to piggyback off of what Zafar has said, so there are a lot of orders in place, but those orders we assume that tenants are aware of those orders. We get a lot of calls from tenants who appear at their hearings, and they're not aware of what defenses that they can raise until after their hearing. And I'm not sure if you all have been to landlord-tenant court, but oftentimes the landlord's attorney will catch the tenant before an advocate will, and they don't necessarily bring up those the moratoriums that the tenants can raise. So unfortunately, a lot of those moratoriums aren't being raised unless the tenants are advised of it. As Zafar mentioned, our concern is that tenant holding over cases are going to increase in filings, because currently I don't interpret the CDC moratorium to necessarily protect tenant holding over cases. And additionally, I don't believe Governor Hogan's order mentions anything about tenant holding over cases, and there are extremely limited defenses that can be raised in that regard. What we're also seeing is there's an increasing number of illegal evictions that tenants are claiming that are taking place. We're receiving volumes of calls from tenants who are saying they've been evicted without receiving any court notices, without receiving any writs. I just had a case on Monday where a tenant had never received his court summons. He was notified by his landlord that he had a hearing, called the clerk's office, and at some point the clerk's office wasn't even aware of a hearing. I think he came the day of, and at that point, that's when we were advised, but we're not quite sure if it's because of the delay in the mail or if there's some issue with the sheriff's office. We're not sure, but tenants are getting evicted without having notice. Also, as mentioned, tenants are having extreme difficulty finding housing because anytime that there are rental or eviction filings, even if a judgment isn't entered, tenants are saying that is kind of putting them on a blacklist, and it's making it extremely difficult for them to find additional housing. I think that's pretty much the bulk of what I'm seeing. We're still in the courthouse, but of course, I'm at Community Legal Services, I manage our program. We rely on the private bar to support us and to help us. We do provide a small stipend, but that's contingent upon us having those funds. So of course, the increase in funding is great because that way we can then continue doing our service in the courtroom and helping tenants try to keep their housing. And statistics show that having access to counsel you're more likely to avoid an eviction if you do have that access to counsel or even some type of advice. So thank you for having me.
Thank you, Zafar and Kayla. That was really great. I think now we're going to hear from Matt Stubenberg. Matt will talk to us about the data dashboard that you're putting together.
Yeah, thanks so much. So I'm Matt Stubenberg from the Data and Legal Technology Committee. And what we've been trying to do for the last couple of months is put together a data dashboard to track some of the access to justice measures that have been impacted by COVID. And before I show you the dashboard, I just want to talk a little bit about some of the data that we were able to collect and some of the kind of hurdles we had to overcome. So a lot of this data is in a lot of different spots. Different agencies put out data on their own website. They put it out in different formats. Some of them will put out data once a year, others once a month. And so it was a bit of a challenge just to get the publicly available data. I will commend that the court has started to release more data in terms of kind of FTPR stuff, which made some of the housing data much easier to collect. But we also had to collect data from scraping case search, from in one instance, we were able to get PDFs with all the information, but that's kind of difficult to turn into an Excel sheet and then turn into graphs. And so we had to build little programs to kind of pull the information out of the PDF and then into an Excel sheet. And just to show you one example, for DV cases, there are PDF reports on the court's website that has all the DV instances for particular counties for a particular month. But that very quickly adds up, right? There's 24 counties, there's 12 months. So we're already looking at 288 separate PDFs filled with data for just 1 year. And so we had to get creative with how we pulled out all the information. And we also had a lot of nonprofit legal service providers volunteer their information for the dashboard. So we're very thankful to groups like Maryland Legal Aid and VLS who donated their data for this. So go ahead and show you what I have here. Okay, so we have this kind of general information page. I'm not going to go through the whole thing because I don't think we have time, but we can put the link in the chat and people can explore it on their own. So one, we wanted to make sure that we were clear on where we were getting all the data sources. So if you're interested in seeing where some of the numbers are coming from, go ahead and take a look here. And then I want to talk about the housing dashboards. So right from the beginning, housing was going to be a big part of this dashboard, right? The eviction problem was always going to be something that was a huge indicator of access to justice. And so we were able to combine a whole bunch of data on that issue. So right here, we have failure to pay rent filings by county. You can see, right, there's a massive drop in March to almost zero, but we could start to see that some of these FTPR filings have started to increase. And we tried to make it as accessible as possible so you can compare different counties. So if you're one of the smaller jurisdictions that's down here, and it's kind of hard to see exactly which particular or how the line graph is actually affecting your county, you can go ahead and you can actually just select this and you can start to compare different counties, and it'll kind of change the scale there for you. We track, this graph is also affected by the county, but you can track the number of evictions versus the actual number of FTPR filed, because there's sometimes going to be a difference between filings and actual evictions. And this also has warrants of restitution. We track the foreclosure notices because we want to make sure that we're tracking not just people who are renting, but also mortgages that are being foreclosed on. And then we were really conscious to try to have as much data about the racial disparity and impact that access to justice and COVID-19 has played. One of the biggest hurdles to that is a lot of civil data doesn't collect race as one of the inputs. And so it's usually pretty difficult from a lot of the state and government departments and the information that they release. We were able to get some of that data from the nonprofit legal service providers who do collect race as one of their inputs, and they were gracious enough to give that to us. So we can actually start to track some of the disparity between how race is impacted when it comes to housing. Another important graph I want to show is the People's Law Library website. They were able to give us their web traffic data, which I think is hugely useful because it can be an indicator of problems that are coming down the line. If you think about it with an eviction case, you have the landlord attempting to collect, and then you have the filing process by the time it hits the court. And then by the time the court puts it into a report on their website, there may already be a really big caseload there. But People's Law Library is able to give us that data on a much faster instant. So we can see what people are searching for on People's Law Library in the aggregate. And so, for instance, right here, we have a general page on landlord and tenant cause of action when things go wrong. And we could see it kind of trending at about 2,000 hits per month back in May of 2019. It's gone up, and then it stayed around 4,000. It dipped a little in April when there was the eviction moratorium. People still had savings, but recently it's gone up to about 6,000 hits per month, showing you that people really are concerned with how they're going to pay the rent here. We were also able to get Fair Housing Action Center intake data, which is really good because they do a lot of kind of specific housing issues. We're also tracking small claims. Small claims is a big issue. We want to be able to track that. We don't have as much data for small claims right now. We hope to have some more in the future. But the same thing, you can track your county and you can see where the small claims filings are compared to 2019, compared to 2020. And this is just a statewide. So you can see that small claims overall is going down as the courts have been closed. It's been harder to file these, but we all suspect that this will probably go up fairly soon. And this is also another really great place where we have race data from MVLS and Maryland Legal Aid. And then the last thing I want to show here is we have kind of a miscellaneous dashboard where we're collecting a lot of stuff that hopefully will get its own dashboard page soon enough. One of them is domestic violence issues. So this was a big issue from the very beginning. We see a drop in peace orders and protective orders being filed in April, and then it spikes right back up. This should be noted that this doesn't mean that domestic violence isn't happening. This is just court filings. And so it could be that people were afraid to go to the courthouse, to leave the house. And then, we're going to follow this trend as it goes on and track whether or not it keeps going up. As savings are depleted, as people continue to lose their job, are domestic violence issues going up. And one way we can hopefully have kind of a canary in the coal mine is, again, with the People's Law Library data, as they have a peace order and a protective order page. And so we can start to see it go up about the same time the orders start to go up. So hopefully this will give us some indicators as to that. And then just very briefly, this is a map of Maryland. It has all the broken up by zip code, and it has the average upload speed for that zip code. And according to Zoom's website, in order to have just a normal video group call, you have to have at least a 1.5 megabit per second upload speed. And that's just kind of, without all the bells and whistles, just a normal video group call. And so all the counties in red don't even meet that threshold, or all the zip codes in red. In order to have a kind of a normal Zoom call, a Zoom call that we would all consider normal with screen sharing and multiple people, kind of decent video, you need to have a 3 megabit per second upload speed. And so all the counties in yellow meet that first tier, but they don't meet the second one. And so as courts move online to more and more Zoom hearing, it's important to be cognizant that there are zip codes where the average person with the average internet speed won't be able to fully participate in those Zoom hearings. I plan for this to be kind of a live dashboard. We're going to continue to update it with new data. We haven't been able to put all the data on there yet that we want. We're hoping to add 211 data, some SNAP benefits data, unemployment benefit data. We just wanted to make sure that the data that we had was kind of properly represented before we started adding in more data. And we did have some kind of interesting challenges with how to represent the data. There's a careful balance between putting too many charts and graphs and demonstrating every possible angle versus giving kind of the best information first and foremost so that nothing else is lost. And so hopefully we walk that line in a kind of adequate way. And so that kind of is the data dashboard. I'll go ahead and put the link in the Zoom chat. Does that sound right? About right, Rena?
That would be great. Thanks, Matt.
And then I guess we're almost low on time. I don't know if there's time for questions, but if Rena gives the okay, I'm happy to answer questions.
I think if anybody has a question, we can take it. I mean, we may run over a few minutes, but any pressing questions for Matt? Matt, that's really outstanding. It's a great presentation. It's really interesting and important work. So thank you very, very much.
Thank you.
Quick, Matt, good work, Matt. Quick question. When you state the difficulty that some regions will have in taking advantage of the technology for communication, I'm assuming that those areas, the children who are children in public schools will also be having the same difficulty accessing digital learning. Is that correct?
Yeah, you're absolutely right. The same Zoom upload speed requirements apply if you're on a Zoom court hearing, or if you're on a Zoom class for public school, or if you're on any kind of other Zoom call with your doctor. It's going to affect all of those different areas.
You know, I want to comment here. We have not taken this issue in our recommendation, but that is the nearest thing to a death sentence for a kid. They will not be able to learn anything. Lots of them in the city and lots of them in the county. It is a scary, frightening proposition, and it's going on right now. I just want to put it out there because those are the children of our clients. So the children can't access it, technology, and their parents can't either. And that is something we need to be fully aware of. It is going to cause this divide between the have and the have-nots to be as wide as possible, with all the other ramifications in our society. That, to me, is the most pressing situation in this country right now. It happened in the 30s during the Depression and after. Poor people went further and further and further behind. And it took a long time. They didn't get anywhere. It's happening again right under our eyes.
I think that's well said. I'm sorry, Matt, go ahead.
No, that was a good set. That was very well said.
Well said. And I think the most unfortunate legacy of poverty is more poverty for succeeding generations. And it's instead of us moving forward, we're in real danger of falling back. Rena, is there anything else we need to do from a business standpoint before we close?
I just want to quickly make our task force members aware, with the information that was shared here, there's a lot of information that we need to put out before Marylanders so that they can understand their rights. Zephyr and Kayla went through briefly what people and sort of the confusion that people may be facing in the housing arena. And so I just wanted to make sure task force members are aware that we are going to be hosting community forums. The task force will be, and we have 5 scheduled. We have 6 dates, and we think we will fill all 6. We are going to be offering them in Spanish as well as in English. We did a first one on evictions. I think it was mentioned before, and we've gotten over 2,200 views, but because that is on demand, we still have opportunity to publicize it so people can understand their rights and get more information. So these kinds of forums, we're hoping to both disseminate information about rights, also resources. A lot of these committees have really been working on shoring up their resource books and making sure all the resources are available in one place. And then also questions from the community and really understanding sort of what people are facing. And then quickly, I didn't want to end the meeting. If we can forward to the next slide. One of the things that we really do, and you will be receiving more information in addition to the substantive work, is really thinking about how do we amplify our message. There's a lot of opportunity. There's a lot of good work being done. One of the things we're going to focus on in the next phase of this is connecting you all as task force members to this work in a personal way. Your passion, the connection that you have to your own work, whether it's in this civil legal space or whether it's outside, finding those connections and putting your passion and your stories out there. Thinking of ways that you all can be spokespeople in your own right through your work, but just connecting that work to this, getting your understanding and your stories about why access to justice is important to you. We'll be working on that, and we'll be reaching out to you personally in regards to some opportunities that we have lined up to do this. And then, of course, when we have events such as the community forums and others, how can we share those within your networks? The past, when we sent out the letter for the funding request, we did start to attempt to do this and have sent you all some social media posts that you could post on your own, sent you a hashtag. We didn't have great success with that strategy. We're going to build that out more and give you all more information. We do think that there will be a multiplier effect if we do this kind of in a concerted way and use sort of your networks and social to do this. We are also going to be working on seeing if we can now really think about, because we have so much substantive work behind us, getting more placements in print and then also TV and radio. So, if you are interested and are willing to be spokespeople, we can really think about other opportunities as well to really amplify our message. So I just wanted to kind of inform task force members, and always all the information that we are doing substantively is available on the website, the Attorney General's website. So, if you're trying to wonder where should I guide people to in terms of where that video on demand could be about that eviction, you can find it on that website. Next slide, please. Finally, I did want to remind everyone, initially when we started out, we had 3 meetings in mind, but given how much we need to do and make sure that we get your approval on the recommendations, we have added an October meeting. Initially, I communicated that meeting would be from 10 to 12. The meeting will actually be from 9:30 to 11:30. And so I will be sending you information in regards to that, but I just wanted to highlight that there will be an additional meeting in October. Next slide, please. And finally, I wanted to share with you all sort of, the rationale and what we are thinking in terms of how we will be receiving feedback from you all as we're driving towards this final report. So we expect that the task force will be delivering a final report by mid-December. And we, working back from that, we hope to have a final review of the copy of the report at our November meeting. And the reason for our October meeting, really to make sure that now that we've gotten the initial sort of feedback from you all at this meeting, the committees will be working to finalize their recommendations, and we hope to have a review of those at the October meeting so that we can work towards this report deadline that we have. So I just wanted to give an overview of that and that timeline. And that's it on my part, Attorney General Frosch. Thank you.
Well, first, let me say to both Rena Shaw and Judge Andre Davis, thank you so much. Those were great presentations. Thanks to everyone else who presented. Thanks to the committee chairs, the committee members, and most of all, to all of the task force members. I think we're making great progress. There's a lot that remains to be done. We have to bring this stuff to life too, but I think we're making terrific progress. So I thank you all for your work, your support, and we look forward to seeing you on October 15th and certainly hearing from you in between then and now. Thanks a lot, everybody. Have a good day.